everyone, and welcome to the first episode of Compliance by Design, a podcast about the future of compliance. Here to talk to us today about the upcoming changes to the US AML framework is Rob Johnston. Rob is a lawyer and a partner at the law firm Lowenstein Sandler, where he advises funds and managers on, among others, regulatory compliance, SEC examinations, and enforcement. So certainly well placed to talk to us today about the future of AML compliance in the US and what asset managers can do to stay ahead. Hi, Rob. First of all, thank you for joining us on our first ever episode, and we're very delighted to have you here. And of course, I've met you before, and you and James go way back. But for our listeners, I wonder if you could briefly introduce yourself and what you do at Lowenstein.
Yeah, sure. So, hello, everyone. Nice to see you again. I'm a partner at Lowenstein Sandler in the New York office. I've been here roughly 4 years. My practice focuses on government investigations, internal investigations, regulatory exams, anti-money laundering, anti-corruption, trade sanctions, securities laws, compliance, and governance matters. And that's very similar to the things I worked on when I worked with James, when we were both at Oxif Capital Management. I was in New York and James was in London, but we worked on a number of matters together.
Yes, and I'm sure you have war stories to share, perhaps offline or for subscriber-only content.
That's right.
But we're here today to talk about the US regulatory landscape and some rather large changes that have come into force or at least have been proposed within the last 12 months. And these last 12 months have been quite eventful for compliance teams in the US. There's been the rollout of the Corporate Transparency Act. There's been the final rule. Well, I say recent, actually 6 or 7 months back now, but the FinCEN final rule on AML. And there's been quite a lot of back and forth. So starting with the Corporate Transparency Act, we know there's been some whiplash. It was introduced, and then there were some injunctions and a SCOTUS ruling, and more recently, FinCEN proposed to pare it back somewhat. I wonder if you could maybe give us a bit of a state of the union, if you will, on what the current status is on the Corporate Transparency Act.
Sure. So the Corporate Transparency Act was originally passed in 2020 as part of a larger bill called the Anti-Money Laundering Act of 2020, which itself was part of the National Defense Reauthorization, which funds the armed services. The bill itself actually passed by supermajorities in the Congress, so it had both Republicans and Democrats supporting it. Fast forward a few years as the Corporate Transparency Act is getting implemented and the rules are being promulgated. Different litigants began litigation in different district courts across the United States. And oddly, right before Christmas, the Fifth Circuit motions panel reversed or stayed the nationwide injunction that a trial court in the Fifth Circuit had issued. Then just days later, after Christmas, a substantive hearing panel on the same case lifted the stay. In other words, put back into place the nationwide injunction. So for those of us following this closely, we were generating conflicting client alerts, days apart over the holidays where most people are not really paying attention to the CTA and have better things to do. So it created tremendous market confusion, both amongst my law firm partners and as well, with our clients. And against this backdrop, January 1 was the compliance date. So people were a little bit at a loss as to what they were supposed to do. But then subsequently, the Treasury Department, FinCEN, which is part of Treasury, decided to change the rules of the game, and they issued what they called an interim final rule, which now redefines the scope of companies that have to comply with the CTA. So previously, it was any company incorporated in any U.S. jurisdiction and any non-U.S. company that had filed paperwork seeking authorization to do business in a U.S. jurisdiction. Now with the change, it is only going to apply to companies, non-U.S. companies that seek authorization to do business in a U.S. jurisdiction. For example, if you have an English limited company that for some reason, rather than setting up a New York company, just decides to directly seek the ability to do business in New York, that company would have to do a CTA filing in the United States. So we've gone from 30 million companies in scope down to 11,000. As you know, in Europe, you've been doing this for quite a long time. And actually, over the last year or so, when I tried to explain the CTA to European lawyers, there was often silence. And then they would look at me and say, you haven't been doing this all along. What's the big deal? So It'll be interesting to see. The United States sort of briefly came into alignment, I think, with a lot of European and other jurisdictions that have these types of beneficial ownership databases. And now, just as quickly, has sort of fallen back to where it was before, and query whether that impacts the way other jurisdictions see the United States in terms of risk, and whether the FATF will take any sort of action.
Well, that's really interesting, Rob, and thanks for the broader context here. Maybe this is quite topical beyond just compliance, but particularly relevant to what you're saying. This on again, off again approach. How have your clients been dealing with this whiplash? How have they adapted to these constantly changing obligations? I mean, you do this for a living, and designing compliance policies is something that takes time, and there are multiple layers of approvals, stakeholders involved at multiple levels. How can asset managers plan ahead with this level of uncertainty as to their obligations?
Right. I think it's very frustrating for everybody. A lot of companies spent a lot of time, resources, and money trying to figure out how to bring themselves into compliance by January 1, 2025. And now, a lot of that work was for naught. So it's difficult to be the messenger in those situations, and trying to explain sort of the schizophrenia in the courts, where the same court, reverses itself in the course of a holiday week at the end of the year, and generate a lot of client alerts, and a lot of client phone calls to try to keep them abreast of what the current lay of the land is. I do think with respect to CTA, we've probably come to a resting point, at least for the immediate future.
Well, so now I guess everyone's focusing, if that's reached a resting point, everyone's focusing on the next big change brought around by FinCEN,
Yes.
the changes to the AML regime. Could you give us maybe a bit of a primer as to what the final rule entails for the Bank Secrecy Act and the US AML framework in general?
Sure. Everyone in the US, including fund managers, are subject today to something called the Money Laundering Control Act of 1986. And that broadly prohibits knowingly dealing in the proceeds of criminal activity, or the money related to criminal activity. Importantly, knowledge can be established either through actual knowledge, or through willful blindness or conscious disregard of the truth. And so, as applicable to fund managers today, LP were to walk into your offices with, $50,000 in cash that smelled like marijuana, right? That would arguably be you were on notice that those are the proceeds of drug sales, to take sort of an extreme example, right? And so, in that sense, everyone has to do some diligence on their limited partners, on their transaction counterparties, in order to satisfy obligations under the Money Laundering Control Act of 1986. The Bank Secrecy Act was originally passed in 1970. It's been amended along the way. The Patriot Act in 2001 is the most substantial amendment. And the Patriot Act created a concept of a defined term of financial institution. And at the time, there was an initial draft of the Patriot Act that had registered investment advisors included in the laundry list of covered financial institutions, which includes banks and broker dealers and other sort of more traditional financial institutions. By our count, this most recent attempt is the fourth attempt in 20 plus years to bring RIAs within the definition of financial institution and subject them to the BSA and the Patriot Act. So the Bank Secrecy Act requires financial institutions, which now includes registered investment advisors, to have what we call the 5 pillars of a compliance program. So the first pillar is a designated compliance officer. The second is policy, procedures, and controls. The third is independent testing, which is important for RIAs because independent testing means a function other than compliance, if compliance is responsible for AML. And many RIAs do not have an independent audit function because there's no regulatory requirement to have one. So they'll have to figure out how to outsource or otherwise get the testing done. And then training. So those are the 4 pillars. Then the 5th pillar, where there's actually a proposed rule that has not been finalized, is the customer identification program, also known as KYC. Now, that arguably is the most important part of an AML program, the customer identification and KYC component. That rule has not gone final. However, at the moment, the compliance date is January 1, 2026. And so that's posing, as every day passes and we get closer to that January 1 date, it makes things a little bit more complicated as to how do we stand up a BSA program when the most important pillar does not yet have a final rule. Now, no one has sued to stop this one yet. I would also note that that rule around CIP is a joint rule with the SEC, and their new chairman was finally confirmed by the Senate. So I don't know where that proposed rule sits on his desk, and how far down on the stack of things for him to get to. But we are, again, in a little bit of a tricky situation similar to CTA, where we have a final rule, RIAs as of January 1, you will be subject to the BSA, which means you have to do suspicious activity reports, you have to do currency transaction reports. However, the most important part of your program doesn't have a final rule yet.
It sounds like, Rob, it would be a reasonable approach then for, given the scale of changes that a manager might need to make to comply with these rules, it would feel that a reasonable approach would be to continue to wait and see, acknowledging that that can cause some pain down the line, obviously, if they move ahead with giving the final rule.
So I think certainly for managers that are using outsourced KYC providers, so many of the larger, more complex managers in the US, well, the funds are Cayman or BVI or Luxembourg, so those funds are already subject to a very more robust and heightened KYC standard. And often the KYC is being done by some third party, often a financial institution in one of those jurisdictions. And so they're already identifying all the UBOs, at a 10% or greater level. They're doing political exposure screenings and sanction screenings. So I think in many instances, particularly where an administrator is being used, you can certainly continue to wait and see. For all managers, but particularly others that don't have an admin, sort of an intermediary step that we are recommending that people take is to meet with the internal finance and accounting people at the manager and just start documenting all the ways that money moves through the organization. So, and then most likely the finance team has already documented this, it already has a set of controls laid out, but just making sure that there is visibility from when an investor subscribes, the money is sent from their bank to the custodian bank to a fund capital account, for example, or what are the controls around vendors and setting up vendors. If a vendor calls and they want to change their wiring instructions from London to Cyprus, who is confirming that that is accurate? Is there a mechanism to escalate that to compliance and start making sure that some of the basic information piping is in place so that we would have the theoretical ability to identify suspicious activity on January 1st?
Well, it sounds like ultimately nobody knows what's going to happen with the FinCEN rule. So let's sort of indulge in a fantasy for a moment and assume, or pretend rather, that the wording is going to come into effect as currently phrased in the rule, in the 310-page rule.
Yes.
One question I had on this is there's a bit of an ambiguity as to who it applies to, and I don't mean advisors versus banks. I mean KYC, know your customer identification program. Who's the C? Who's the customer? Is it investors in funds? Is it transaction counterparties? We're hearing both sides of this, and there's a specific footnote that I'm referring to in the rule, footnote 45, that seems to suggest it's just fund investors, but the rest of the rule is ambiguous. It seems it could apply to both. What's your take?
So my initial take was I thought there was a drafting error in the CIP proposed rule because customer is defined as the entity or person that has an account with the manager. And so I said, great. All of our fund managers only have to KYC their own funds. This is not going to be hard at all.
Yeah.
And then subsequently, in some of the frequently asked questions, FinCEN said that advisors are supposed to conduct risk-based analysis of the AML terrorist financing and illicit financing risks posed by their investors in the advised funds. And then similarly, the suspicious activity reporting rules will require reporting transactions. The thresholds are low, either above $5,000 or $25,000 that are potentially relating to criminal activity. And the standard is by, through, or attempted by, through the RIA. So that would then sweep up, at least in the suspicious activity reporting requirements, if you have a counterparty that seems to be engaged in illicit activity or money laundering, and somehow the RIA and one of its advised funds is involved in the transactions. Another place this could arise, and this is not an uncommon situation, right? If you think about the Russia sanctions, a number of advisors had a lot of Russian money, and none of those LPs were subject. They might have been higher risk, but it wasn't illegal to take their money. And then Russia invades Ukraine, and now a bunch of these people end up on various sanctions lists around the world, and we have to figure out how to block their accounts. Well, similarly, you could have an investor who comes into your fund and appears to be low risk, and then 2 or 3 years later gets caught up in a massive financial fraud and is being prosecuted by the authorities for a litany of financial crimes. Well, now are you feeling so great about that person's, $1 million that's invested in your funds? Or do you think that that's potentially the proceeds of criminal activity? You might have to decide what to do from there, including, whether or not you file a suspicious activity report or if you block the account and don't allow any future redemptions out of the account. So the rule as drafted, because we don't need the customer identification program in order to do the suspicious activity reporting, which is part of the final rule, I think, yes, there is going to need to be monitoring of transaction counterparties as well as LPs because of this concept of transactions by, through, or attempted through the RF.
And just to clarify that point, Rob, the reason you think that it might apply, CDD, customer due diligence, may also apply to transaction counterparties is because the way the SAR obligations are phrased in the new rule. So because there's an obligation to lower the threshold and file SAR reports in respect of suspicious activity with counterparties, then you retro-engineer it, and you understand that because of that, we're having to do KYC, as we call it, on transaction counterparties too.
Right. And in order to fully analyze whether something is suspicious or outside of the expected nature of the counterparty or limited partner's behavior, right, you're going to need to have done some sort of customer due diligence or diligence on that counterparty or that LP. Otherwise, you sort of lack a baseline in order to say this is strange or this is not strange. For example, if you have an LP who switches their banking and address from Switzerland to Monaco, does that mean that they're necessarily trying to evade taxes or launder money? Not really. But if you've done customer due diligence on them and you realize that they married someone and moved or something, and there's a reasonable explanation for that change of address and change of bank, or maybe there isn't, and in which case, you have to consider whether or not a suspicious activity report filing is necessary. And really, it's suspicion of potential money laundering or illicit activity.
But just the monitoring of these transactions itself seems like a mass. I mean, we've been doing it in Europe for a long time, so we're used to it. But for RIAs in the US, especially ones that might not have a fully global practice and who might be domestic, focusing on domestic deals, this is quite a gargantuan change requiring quite a lot of effort. What does this mean in practice? Or rather, perhaps, what would you say are the top 3 things that firms and your clients should be doing right now to keep on top of that, assuming it all stays in place as proposed in there?
Right. And I think that's right. I think smaller RIAs, with certainly ones that don't use the third party administrator, may be higher risk in terms of the limited partners that they would accept into their fund for various reasons, or just simply because they don't seem to have this front of mind for various reasons. I think even if you loop back to the Money Laundering Control Act, right, where there is this concept of being willfully blind to facts and circumstances suggesting money laundering, today could be a violation of law. So I would suggest to those managers, yes, the BSA doesn't apply to you yet, but you are subject to the Money Laundering Control Act. And if you have no policies and procedures and no controls in place, you're not going to be in a very good place to defend yourself against a willful blindness case, right? Because we didn't even check. So how can you say you weren't willfully blind? And so I think, for those folks, they would certainly need to put into place some sort of policy and related procedures for doing some basic customer due diligence on their limited partners and their counterparties. Everyone should be doing some form of risk assessments. Do their products and services, are those more susceptible or potentially attractive to money launderers or terrorist financiers or not. There's various guidelines actually in the 300 pages of the release. And the other piece to consider, like I said earlier, is to sit with the finance or accounting team and just try to understand what financial controls and accounting controls are in place already. And that can help people get ready for January 1, assuming that date doesn't change.
So it's a big if.
I would say this is all good corporate housekeeping anyways, right? And
I was also going to just jump in and say,
yeah,
I mean, PD, we see amongst our clients that are global asset managers, let's say, that most, if not all, have some kind of policies and procedures in place in the US for monitoring transaction counterparties, whether it's to detect any sanctions issues on DOE, etc. So I can see how this could look like a gargantuan task, as you said, but also I can kind of see how this is just an evolution of the existing programs that they have in place. And maybe it's a good excuse or a good reason to take another look at those towards the end of this year versus it being a very significant overhaul.
And James raises a good point with respect to sanctions. So civil violations of the sanctions regimes maintained by OFAC are actually strict liability offenses. So the mere fact that you processed a redemption to someone on an SDN or other sanction list in the United States is a violation of law, full stop, and you could be subject to pretty severe civil penalties for that. And then on the criminal side, also you have this concept of willful blindness.
And Rob, just to interrupt you, to be clear, that's failing to identify a transaction counterparty or a UBO, an ultimate beneficial owner of a transaction counterparty that is subject to an OFAC sanction, for example.
Right. So, for example, let's say that there is a LLC that is 55% owned by a sanctioned Russian, right? That LLC now is also subject to U.S. sanctions because it's more than 50% owned or controlled by a sanctioned person. And so if you were to process a redemption back to that LLC, you've now violated U.S. sanctions laws, even if you didn't know that the LLC was ultimately owned by a sanctioned person. Now, you could also be prosecuted criminally for that act where the government can establish that you knew. But again, it's like the Money Laundering Control Act, knowledge can be established through willful blindness or conscious disregard. So again, if you don't have any sort of basic policy and procedures in place, it becomes very difficult to defend that fact pattern because you're really reckless, basically, in the eyes of the government, right? And so, again, I would say to smaller managers who perhaps haven't been focused on this, you are already subject to Money Laundering Control Act, and you're subject to the U.S. sanctions regimes. And both of those bodies of law really require you to be doing some sort of basic diligence on your transaction counterparties as well as your limited partners.
And Rob, we include private and public transactions. Well, certainly we include private transactions in that. So whether it's a credit deal or a traditional private equity deal, purchase, whatever it is.
Well, absolutely. So on the sanctions front, and even on the money laundering front, I think the exchange traded public securities is definitely low risk. Mm-hmm. However, when you get into the private transaction space, whether it's direct lending or syndicate lending or private equity investments, where you don't have sort of this anonymous faceless person through an exchange, that's where these risks really start to creep in on the transactional side.
Yeah. And PD, your team do a lot of this work anyway in the US, but I think it's fair to say that 4 years ago, there was more resistance to running transaction counterparty AML, identifying UBOs, asking for corporate ownership information. I would say, I mean, Europe certainly, but even in the US over the last 2-3 years, that's become reasonably commonplace to do that between US counterparties. Would you agree?
Absolutely. And we've seen certainly less resistance. There's still a lot of resistance, but even when dealing with SMEs in the US as counterparties, so borrowers, sellers, purchasers, etc., we're seeing, especially, I would say at the beginning, starting in early 2024, we've seen a slight shift in the way they react to KYC requests coming from, say, our clients. There's certainly getting more used to the idea of receiving these type of requests and having to disclose beneficial ownership information. So there seems to have been a slight shift or a gradual shift even among US counterparties towards more KYC. That's quite interesting because even when we're looking at the FinCEN rule itself, that points to what we would be looking at from a European perspective as a move towards a more consistent global model with US standards just generally, and US standards and culture more closely aligning with European ones, which is slightly sort of counter the trend that we've been seeing the past couple of months more broadly geopolitically. But I guess that prompts a question for both of you. Is this just the start? Do you see US compliance moving towards a more closer alignment with European style compliance and standards?
I think for multinational advisors or companies, they're going to have to adopt the strictest, or what I recommend is adopting the strictest standard to which they're subject. So in the US, under the customer due diligence rule, it's only required for financial institutions to identify a beneficial owner to the 25% level, where I think in Europe, it's certainly market practice, if not the law, to do it at the 10% level, right? And similarly in Cayman, some of the other important jurisdictions for funds. And so if you are a fund manager with Cayman funds and Irish funds and Luxembourg funds and a London office and a Hong Kong office, my suggestion for simplicity's sake, rather than having to parse whether any particular transaction touches upon certain jurisdictions, is just say, okay, the most stringent standard we're subject to worldwide is a 10% UBO identification. We'll just make that our standard for every deal we do, and we don't have to spend time and potentially make a mistake figuring out which standard applies to which transaction on a deal-by-deal, day-by-day basis.
And Rob, that 10% could be, for example, a US manager that happens to invest ultimately through a Cayman fund,
right,
double top, presumably.
And we're seeing our clients take exactly that approach, Rob. So it's the most stringent standard applied globally. And then, of course, if the specifics of the case don't require that lower threshold, that 10% threshold, because maybe Cayman aren't involved, etc., there's just scope to take a view. It's always about the risk-based approach anyway.
So I have seen some investors push back, for example, when they're investing through a US investor is investing through a Delaware feeder. And they're saying, oh, no, we're in the United States. It's a 25% requirement. So that's all that we're going to give you. And, as a legal matter, they're often correct. And so then as a fund manager, you just have to make a decision as to whether to allow the exemption or to push for your policy, which in that instance is more restricted than the actual regulatory requirement in the particular jurisdiction.
But if it was a Delaware feeder into a Cayman fund, would it change? We're probably going down a rabbit hole that we don't need to go down.
Right. Well, it depends. If they were more than 10% of the overall Delaware feeder, because then the Delaware feeder becomes the customer of the Cayman.
Yeah.
But yes, exactly. This is exactly why I recommend a client just to have, if you're subject to 10% anywhere, just say 10% across the board, and then you don't have to engage in this brain damage, hopefully on a daily basis. The thing I think is also generally different about the United States is the customer identification rules here are much more concept-based. So you have an obligation to know your customer. You have an obligation to identify your customer. And the law and the regulations do not spell out with granularity, if you're dealing with a public pension, you must collect these 5 documents. If you're dealing with a corporation, you must collect these 10 documents. Whereas I think other jurisdictions, such as the Cayman and some of the European jurisdictions, it is very prescriptive on that level of granularity. And so that's another place where sometimes you can see some divergences. In the US, we could satisfy this amorphous identifying our customer concept without, getting the 7th or 8th document that might be required under the Cayman regulation. So slight gaps on the margin, but I think generally the concepts are the same.
Yeah, we see that as well. There tends to be some level of permissiveness there, but then you have some jurisdictions that are far more prescriptive on what the documents are. Fortunately, across the board, we see that there is a bit of a scope to take a view and be flexible as to what is actually required, as long as the key information is being brought out about who the counterparty is, who the beneficial owners are. But I wanted to move on, given mindful of everyone's time as well. It seems these days it's quite hard to have any conversation that doesn't naturally just end up being about artificial intelligence. And especially given, who Avanti are and what we do, I think we'd be remiss if we didn't cover at least a little bit the impact that AI is having on legal services. So one for James to start with, what's your take on how AI is shaping compliance and legal workflows?
I'll focus on compliance because legal workflows will be a 30-minute answer that probably no one wants to listen to. So I'll focus on compliance. I would say I haven't seen yet very compelling uses of AI. And Rob, if you've seen anything very exciting, jump in and correct me. Yet I haven't seen very compelling uses of AI around compliance. I broadly bucket it, I think, into two different problem statements where AI can help with compliance. Tell me if you guys agree. Number one, increasing regulatory burdens, increasing frequency of regulation, need to track what's going on and how it applies to you with increasingly complex global structures. So, use case number one, AI should and can already play a reasonably effective role at helping you manage that kind of regulatory framework landscape. So, what applies to you? What's changed? Is your current structures and policies up to scratch? Is it doing everything? It can issue spot and it can alert you where there may be gaps. So I think that's potentially one good use case of AI. The second use case, and this certainly applies to legal processes, even though I said I wouldn't talk about legal processes, a lot of the compliance work, and we've spoken a lot about CDD and AML, for example, is still a reasonably repetitive, time-consuming process for people and humans doing that work. A lot of it is still reasonably straightforward work that is not high complexity. And when you look at where has been a lot of success, where AI has been able to speed up and automate and save cost and drive efficiency, it is in those kind of things where you've got reasonably repetitive work that's not overly complex that humans are still doing. So there will no doubt, and it's certainly things that we're digging into in our firm, there's no doubt very significant pockets of work that are being done in a compliance work stream that would be amenable to some kind of AI support to help the person speed up. But as of yet, I've not seen anything super compelling. And then the kind of like stuff that's been around for a while is obviously, you can have an AI system read a passport and do all that kind of, like what is now reasonably straightforward stuff. So it helps with at the kind of more retail end, it obviously helps with scanning information and recognizing identity documents. Rob, I don't know if you guys are working on seen anything any different to that.
So I think a number of the large banks and large broker dealers have invested quite a bit of money in data analytics because they are looking for suspicious activity and anomalies across millions of transactions and tens of billions of dollars on a daily basis, right? And if you are Barclays or Citibank or JP Morgan, there's no way to attempt to do that across your organization other than through some sort of massive investment in AI and data analytics. However, what I'm looking for in the market, and if anyone out there is listening and can do this, taking that idea that the system that Barclays or JP Morgan would have to implement, but we need to dramatically downscale it for a registered investment advisor, right? I think that would be potentially very interesting. Probably simplified and refined set of AI parameters or data analytics parameters to flag for compliance potentially suspicious activity or anomalous activity. And partly too, my concern is that when it comes time to be examined, a Treasury has actually outsourced the examination authority it has to the SEC for registered investment advisors in the AML space. And what I suspect is going to happen on many exams is the SEC is going to come in, and for all the reasons we discussed, the registered investment advisor will never have had to do a currency transaction report because they don't handle currency. Likely will not have done any suspicious activity reports, or if they've done any, it might be like one, right? And the SEC examiner is going to say, aha, you haven't done any of these because you don't have policies and procedures and controls in place. And so then we're going to have to say, no, we do have policies, procedures, and controls in place. It's just we don't have suspicious activity and we don't have currency transactions. Therefore, we've never had to do one. And so I think sort of a reasonably priced, appropriately tailored and scaled version of the big bank data analytics for this industry could be a very compelling use of AI. But that is well outside my forte. So if anyone listening can do that, we should collaborate on how to take it to market.
Well, I think that's a great place to end it. Rob, it's been a delight having you here for our first episode. And we look forward to having you on hopefully soon, perhaps once we know how this FinCEN rule is going to pan out, have you back to comment on that. But just as a final question to end things on, and you can answer this both from a personal place or a professional, what is the best piece of advice you've received in the last year?
Best piece of advice in the last year.
It can be 2 years.
Well, I will say where I've seen folks get into trouble sort of consistently in the compliance space tends to be around fast growing companies or fast growing managers, where the controls and the back office infrastructure don't keep pace with the business. And so, the business is on a rocket ship. They're growing, they're opening offices, they're launching new products, they're entering new jurisdictions. And the compliance and accounting infrastructure, for various reasons, whether maybe it's they weren't given the resources they needed, perhaps they're very reliant on manual processes, they're not using technology to scale with the business. And so then you have a rapidly growing business entering new business lines and new jurisdictions, and compliance can't keep up. And so people are not looking at the risks of the new jurisdiction or the new business line, and the right controls aren't in place to provide adequate support. So that's something I've seen sort of as a repeated theme across industries over the years.
So focus on compliance early.
Or at least have a set of compliance procedures and tools that can scale, right? If your compliance department is still working on spreadsheets and Word documents that are saved locally on their desktop, that is not a compliance department that can scale. And so make sure that they have the resources they need to keep pace with the business where you're in a rapid growth situation.
Fantastic. Thank you, Rob. James, any final words for this episode?
No, not at all. Just to say, Rob, great to see you again. And thanks a lot for being our first guest on our series of podcasts. And as Petey said, we look forward to having you back. Always fun chatting with you.
Absolutely. My pleasure. Thanks, guys.
Thank you. Bye-bye.